really do want to focus on what I see as the implications of this general data protection regulation for scientific and academic research teams. So it's a bit of a reverse order. Perhaps I'm starting more with the narrow, and then David will speak more to the broad. But I hope if you have any questions along the way, don't hesitate to ask. So I guess also by way of introduction, I'm a lecturer in risk and regulation at the University of Edinburgh. And in the past, before I came over to the UK, when I was still in Canada, I worked a bit on data protection regulation, particularly in genomics and its implications for academic research, both, again, within the EU and out with the EU. So in terms of what I want to say, I suppose, in the next 20 minutes is the impact of the GDPR on academic research collaboration and the types of issues that, for those of you that are involved in cross-jurisdictional research, so that means both within your own member states in the EU, but also potential collaborations with teams, say, North America, Asia, Pacific, the kinds of issues you should be aware of. So, as I suspect many of you are aware, the GDPR will come into effect on the 25th of May of 2018. And a number of member states are in the process of amending their current data protection legislation to accord with the new capital R regulation. David will be speaking a bit about the new data protection bill that has been had its first reading in the UK and will have its second reading, I think, on the 10th of October in the House of Lords. It's important to say that as far as the only comments I'll make about Brexit at this stage is that the UK certainly wants and recognizes certainty over data protection following Brexit, which, as far as I can tell, is still on the agenda for the current government, and that it wants strong regulatory cooperation between the Information Commissioner's Office, which is the Data Protection Supervisory Authority in the UK, and European regulators following Brexit, as they recognize that would be in everyone's best interests. What it sets out to do is to negotiate some sort of mutual recognition between the UK and the EU's data protection regimes following Brexit. And this was made clear in a UK government paper released in late August. What is not yet clear, however, is whether this is envisioned as a transitional arrangement before an application for what is called adequacy status is made. The issue, of course, is that given that Brexit is timetabled for March 2019 and the coming into force of the General Data Protection Regulation is May 2018, there will necessarily be a period of time in which the UK adopts the GDPR. Following Brexit, the question is, what will be the status? It seems to be the case that with the adoption of this new, call it Data Protection Act, when it comes into force, perhaps early 2018, the UK will then apply for an adequacy decision from the European Commission. And one would assume, but perhaps we should not make any assumptions, that they will be deemed adequate, provided that they draft a piece of legislation which accords with the new regulation. So that's what I'll say as far as Brexit is concerned and the impact of the GDPR on the UK. So as far as I want to say about the GDPR, the GDPR should have relatively little impact on research, on scientific research, provided that such research conforms to current good practice. I would not say that the GDPR is some sort of radical revision to current data protection regulation frameworks, such as the 1995 directive and the national transpositions of that into your national legislation. So it requires, though, that organizations do some preparative work before implementation to ensure that they comply with the regulation. And it also requires, of course, national governments to resolve some specific details as regards research. But overall, this is not some sort of radical transformation in data protection regulation. And I would say also, as an aside, as for those in the UK, as it relates to personal data, there are no changes to the common law, such as confidentiality, with the coming into force of this new regulation. So let me just now highlight a few aspects that I think are important for you as regards the new regulation, which is to say, The GDPR establishes what is very clearly a risk-based approach to data protection. And so this approach is implementing a kind of integrated system of data protection, both to the data controller and to data processors. And if you have any questions about that terminology, please let me know. I'm happy to answer questions following my talk. So there's a couple of new procedures that are applicable to scientific research settings. The first, I would say, is a designation of a data protection officer, a DPO. In most of the cases for research organizations, biobanks, health research databases, or health database infrastructures, and most data projects, it would seem that a data protection officer designation will be mandatory. According to Article 37 of the GDPR, designating a DPO is mandatory where data processing is carried out by a public authority or body, or where the core activities of the controller or the processor consist of processing which requires regular or systematic monitoring of data subjects on a large scale, or where the processing concerns sensitive personal data and is on a large scale. That would seem to be the case for most research organizations. Sorry, could you give me 1 second? I have to take a break. Someone's knocking at my door. I apologize. 1 second. I apologize for that. So let me continue. So one important criterion here as regards data protection officers is the scale of the processing. And I say this because the GDPR does not define when processing should be considered processing on a large scale, which of course is quite problematic for the implementation of the article. So it would seem to be the case where there is a large, some sort of a significant number of data subjects, research participants that are involved in a project, it would seem to be falling under the rubric of this designation of large scale, and therefore an organization, which could be a kind of network of organizations, designating a data protection officer. So that's something we could talk about further if you would like. And so where a DPO needs to be designated, that person should have professional qualities and expert knowledge of data protection law and practices in the field. So that role will be central in the organizations, as that person will have to inform and advise the data controller on their data protection obligations to make sure that there is compliance with the regulation and to cooperate with national data protection authorities as a kind of contact point. So that is certainly something to keep in mind. Another aspect that I wanted to draw your attention to is the practice of a data protection impact assessment, a DPIA, which is similar to a privacy impact assessment. So with the GDPR, research sponsors and investigators as data controllers will certainly have to practice a data protection impact assessment according to Article 35 of the GDPR. Now, this is going to be a relatively or an entirely new self-assessment exercise, which certainly will prolong the requirements of most funding agencies requiring, as many of you already know, an integrated part of your ethics assessment of a research proposal, such as in Horizon 2020 or an ERC bid, where you describe how personal data will be used and responsibly managed in research. So the data protection impact assessment really is another example of a risk-based approach in the GDPR. So the aim of such an assessment is to assess the likelihood and severity of a risk regarding data subjects' rights and freedoms before undertaking any sort of data processing. Now, to get back to the data protection officer, the nominated data protection officer will have to be involved in this impact assessment process. So that's just another aspect that I wanted to draw your attention to. let me speak a little bit about the rules regarding reuse of personal data for research purposes. So let me just, as a general principle under Article 5 of the GDPR, processing of personal data other than those for which personal data are initially collected should only be allowed where the new purpose of the processing is compatible with the purposes for which the personal data was initially collected. So what this means is that the regulation preserves the previous approach of the 1995 directive, which is further processing for purposes in the public interest or research purposes should be considered to be compatible lawful processing operations, provided, of course, as David will talk about later, where Article 89 is respected, and that's a crucial article for research. So this is good news for health registries, cohorts, and research, and maintaining personal sensitive data for future scientific reuse. That said, this presumed compatibility is not necessarily automatic, and there's certain requirements that have to be met, such as respect of the data minimization principle. And you'll see that in Article 89, which means that where further processing is carried out, the data controller has to make sure or has assessed that the feasibility to fulfill those research purposes do not permit or no longer permit the identification of data subjects. So in other words, a kind of pseudonymization of the data and other sorts of appropriate safeguards are in place. Let me not speak a little bit about research participants' rights. I'd rather not in the interest of time. I think what I want to move towards is transferring personal data to non-EEA countries. I think that will be quite useful as well. So what I want to say here, just briefly, is that the GDPR imposes restrictions on the transfer of personal data outside the European Union, and this has been the case, of course, in the 1995 directive as well. And those restrictions are to what are called third countries, any countries outside the European Economic Area, as well as international organizations. And those restrictions are in place in order to ensure that the level of protection of individuals afforded by the GDPR is not undermined. And so personal data may only be transferred outside the EEA in compliance with conditions that are set out in a chapter of the regulation. And now there's multiple, let's say, avenues where data can be transferred outside the EEA, but they must comply with those provisions. The main one, as I've already highlighted, is what's called an adequacy decision. In other words, the European Commission can render a decision which says that a third country offers an adequate level of protection, and presumably we'll see the UK receiving such an adequacy decision in the next few years. So you'll see that there is a list of countries that are deemed adequate. It will remain to be seen if they will maintain their adequacy status with the coming into the force of the new regulation. And there is also the case that certain countries might have parts of their country deemed adequate, but other parts not. For example, Canada is deemed adequate as far as its federal Personal Information Privacy Act is concerned, but not necessarily across the provinces. So there's a bit of uncertainty as to what will happen with some of those countries going forward. Another case is where personal data can be transferred where the organization receiving the data has adequate safeguards, and a number of different avenues for those adequate safeguards can be provided by, say, a legally binding agreement between public authorities or bodies, what are called binding corporate rules, which is quite interesting, a really new aspect of the regulation, an approved code of conduct approved by a supervisory authority. And for those of you that have been following the news, BBMRI ERIC, the kind of European network for biobanks, is in the process of drafting a code of conduct for biobanks across the EU that they're hoping to have approved by the European Commission in the next couple of years, which would be a tremendous breakthrough for research organizations in the EU. There's also the opportunity for certification as well as contractual clauses. And of course, there's always the aspect of consent provided by the data subject. Now, the last thing I want to highlight is that even in the absence of all of those above measures, what's quite interesting is that the GDPR introduces a new basis for transferring data, which is particularly relevant for researchers that did not exist under the directive. And what this provision says under Article 49 is that a data controller, so let's say a research organization, a research team, can transfer data outside the EU when it's necessary for the purposes of compelling legitimate interests pursued by that controller, which are not overridden by the interests or rights and freedoms of the data subject. So there's a kind of balancing that goes on here, but the key phrase is compelling legitimate interest. And now what's interesting as well is that in the recital of the regulation, it makes clear that legitimate expectations of society, as it says, for an increase of knowledge, should be taken into account when determining when a compelling legitimate interest exists. And certainly one could claim that scientific research is a legitimate expectation of society for an increase of knowledge. Now, let me say as well, however, that to make use of this transfer mechanism, which of course would forego the need for, in and of itself anyway, consent, binding corporate rules, and adequacy decisions, and so on, researchers need to meet a number of requirements. Including among those is the transfer may only be based on this ground if it is not what's seen as repetitive, and it concerns a limited number of data subjects, and the controller has assessed all the circumstances surrounding the data transfer and has on the basis of that assessment provided suitable safeguards. And moreover, the controller has to inform data subjects as well as the relevant data protection authority of the relevant member state of the international transfer. So that is actually a relatively onerous number of requirements, and so researchers might find other bases for such international transfer more convenient, but this is a useful kind of alternative route for international data transfer that could work around countries that are not seen to be have an adequate level of protection as determined by the European Commission, or consent is not seen as a possibility, or there's not some sort of code of conduct, legally binding agreements, or some sort of standard contractual clauses that have been approved by a relevant data protection authority. I think those are the main things that I wanted to highlight as regards scientific research teams. Again, I realize that is a quite specific and narrow discussion of some of the main aspects of the GDPR. Again, I would think that David, I would hope, would highlight some of the more general kind of overview of GDPR.